Welcome to all of you joining us today on the 30th of May in Sydney. We're in the Redback Studios in Sydney. There are no spiders here. And we're going to be talking to you today about our next Barty Perry webinar series, which is Ill and Injured Employees Navigating the Labyrinth. I'm Mark Paul and I'm with Amber Sharp, who'll be presenting with me today. We're from Barty Perry and we're one of the law firms on the New South Wales Government panel to provide employment law advice for New South Wales Government and its various agencies. We already work for some of you and we're looking forward to working with some more of you in time in the future. Now, as I said, this was the second of our three series. Our first concerned resolving conflict and bad behaviour in the workplace. Our next seminar is going to be about odds and ends for employment law. But as I say, our topic today is ill and injured employees navigating the labyrinth. Now, we had a bit of a discussion when we started about whether it's really a maze or a labyrinth. I know there's a difference and I'll tell you what it is. A maze is something that's designed to be confusing, that's difficult, that has dead ends, lack of turns, blind spots. You never know when you're going to get out of it, although you eventually might. A labyrinth is just one long path with twists and turns. It goes uphill, downhill, around about, and you feel like you're getting nowhere, although eventually after you put one foot in front of the other, you come out at the end. So we think it's more like a labyrinth. Yes, there's a lot to know, lots of loose ends, and we're going to try and cover most of them. But maybe it's also a bit of a labyrinth that's made up with some mazes in the middle. We've got about an hour to spend today. We've got quite a bit to cover and we'll be sharing the presentation. What's going to make it good for you and good for us is if you can send us through some questions. We'll try to deal with them as we go through our presentations. If not, we'll pick them up at the end. But please send them through. We've got an iPad here where we can see your questions coming through and we can decide how to manage them. Now, we're going to deal with our presentation as a bit of a tag team, and I want Amber to start because she's going to cover what we're going to do today. Right, Amber?
Good afternoon, everybody, and welcome. In terms of what we're going to cover, part one is going to be understanding the overlapping obligations. We're also going to tease out the difference between work-related versus non-work-related injuries and illnesses for the reason that that can have an impact on what obligations you need to navigate. Part two is going to be dedicated to the issue of common questions. We've chosen a few of our all-time favourites, but by all means, send some more through. And then finally, we'll step through tips and traps for navigating the maze. Now, a couple of points to note from the outset. We are going to have different people covered by different pieces of legislation. So, for example, we're aware that although the majority of employees will be subject to the Government Sector Employment Act, there will be some that fall under the Fair Work Act. So we'll tease out those differences where relevant. The second thing that I was going to note is that the purpose of the seminar is obviously to navigate the maze during employment, but inevitably this feeds to the question of termination in certain circumstances, so how best to minimise risk. So, to part one, sources of obligations. Here they are. There are a lot. Plenty of legislation. We've got workers' compensation legislation. We have the Fair Work Act and or the Industrial Relations Act. We have the Government Sector Employment Act. We have anti-discrimination legislation. Beyond legislation, there will be the Contract of Employment, then industrial instruments, and finally, there will be overriding or supplementary workplace policies. If you happen to be more of a pictorial person, this may assist. You'll see that we've put the Constitution at the top. Sure, it's the vibe, but as you will learn later in the seminar, the Constitution can actually become relevant to the issue of managing injured and ill employees. First up, we're going to deal with the issue of workers' compensation legislation. And at this point, I'll throw to Mark.
Thanks, Amber. Now, workers' compensation legislation is complicated. We've put the two main pieces of legislation, they're up there on the slides for you. I'm not a workers' compensation lawyer. I was a long time ago, and everything I knew has now been replaced by new legislation. But I know enough about it to be aware of some of the important principles. And as Amber said, we need to keep them in mind because they do affect sometimes the decisions we're going to make in how we're going to manage an employee who might be ill and injured where there's a workplace aspect to it. Now, just a quick recap of what happens in New South Wales. Essentially, employees are entitled to compensation where they have an injury that arises out of or in the course of their employment. There can be a refinement in circumstances to make sure that the injury was a substantial contributing factor. That often arises, I think, in what are commonly called psych injuries. And then there's a certain defence that you can have to those claims if you've been undertaken reasonable management action dealing with it. I don't want to deal with that in detail because it's quite complicated, other than to know that the scheme that's in place is about giving compensation to people if they've suffered a workplace injury. It's a no-fault scheme, which means we don't worry about whose fault it is. That's often important to keep in mind when dealing with employment matters, because you'll find that people want to be, or employers are thinking of dismissing somebody because they think, well, they've brought a workers' compensation claim and we don't like that. But it's just a no-fault scheme, and we always take the point of view that you leave workers' compensation to look after itself and don't worry about it too much. But it can make a difference in two little areas, and I'm going to just mention one just briefly about compensation for a moment. There's an unanswered question about whether the compensation that somebody might receive for a workplace injury might be affected, limited, reduced or compromised by the entitlement that a person might receive under discrimination legislation. And that's like a bit of an unanswered question in the New South Wales context, and I think there's an argument to be made that there shouldn't be any double dipping between the two. That's something we might need to keep in mind in some of these cases. Anyway, as I say, there's an overlap between the two, and I just want to move on now to some of the significant things, and I'll just check our next slide up. Yes. This is where it becomes complicated for those of us who are looking after employees. If the employee has some work capacity, then the employer has an obligation to provide what's called suitable employment so far as reasonably practicable. That sounds simple and easy and straightforward, but it causes all sorts of difficulties. The push to have a lot of emphasis placed on returning somebody to work comes a lot out of the good work that was done by Minister Della Bosco quite some years ago. I was at a seminar once where he gave a presentation and said that he'd noticed that when it came to the rugby league, somebody could be injured and they could be back on the field in 2 weeks or 3 weeks or 4 weeks after a bit of physio and some work and some special water that was placed on them at the game or something of that kind. And he thought, well, if we're doing that for those people and it can be done quickly, sure, they're healthy and fit, but why can't other people be dealt with just as well as that and be got back to work as quickly as possible? So you've got to keep in mind that's what the scheme is about. It's really about forcing people to bring people back to work. Okay, now suitable duties, lots of those. It essentially means working out some work activity the person can do that is sensible and necessary within the workplace that's going to help them towards rehabilitation. What's crucially important when providing suitable duties in this employment context we're going to talk about is that the rehabilitation is directed towards returning the person to the position that they held, to their pre-injury duties, or coming to a view about what it is that they can do in the workplace on an ongoing basis. You don't want rehabilitation to turn into rehabilitation that just goes on forever. You need to bring it to a conclusion at some stage. So the message out of all of that is to try and avoid what we call make work, just having somebody do activities for the sake of it. Now, one little case I want to talk about at the bottom, and it's one of my favourite cases, goes back a long time. Yes, it's coming up to its 21st birthday. This is a good case, a good case. It's Mowat and the Midwestern Health Service, an unreported decision, but it touches on this difficult area about how you manage an employee when they return to work. Quite often employers will just naturally see the medical certificate, say, OK, can't lift a 5 kilo weight, or in this particular decision it was a 3 kilo weight, and so we'll bring them back to work. Sandra Mowat was the president of the Nurses Association who brought the case on behalf of a member who'd returned to work with a back injury. She was a nurse with a many, many years' experience, very skilled, very good, very capable, but she had a back injury. They said, well, bring her back to work, put her somewhere where she won't have to lift more than 3 kilos. Now, for a nurse, they're forever lifting, turning patients and so on. That's part of their job. It's a necessary part of their job. And they said, well, we can't have you on the wards. We'll put you in the recovery ward where you're able to monitor people coming out from operations and see how they're going. And she was put in one of those rooms to look after that, and somebody said, By the way, if you have to turn somebody who's on the bed because they're having a fit of some sort, or you've got to move them and you need some help, go over to this wall here and press the red button and somebody will come in and do it for you. Now, of course, what happened is somebody had a fit and her 30 years training kicked in. She went over to the bed, turned the patient to save them, and in doing so injured herself. The case that I'm mentioning here is a workers' compensation prosecution case. The health service was prosecuted for not providing a safe system of work. And what the safe system was that failed was that they had, under return to work conditions, followed conditions to meet the certificate, but didn't think how they're going to make sure that was going to be done safely. So it was just unsafe to put her in a room where she might have to breach the conditions. So that's just a little footnote to tell you, when you're thinking about conditions, don't give up on your obligation to provide for a safe system of work. Now, I think we can just go to the next slide here. Yep. Two more points I want to make about workers' comp. This is the first one. You've often seen this obligation that within New South Wales, you're not allowed to dismiss somebody within the 6 months after they first became unfit. There are some exceptions. If you've got somebody on workers' compensation who, when they come back to work, they don't perform properly, they refuse to follow instructions, they steal from the till, something of that kind, you can dismiss them for that. You just can't dismiss them if they've got a workplace injury for that reason. Or, as we've mentioned on the slide there, they won't undergo a medical test. Now, there's a penalty for this. It's an offence. I'm going to mention the Constitution here because I think there's a bit of an argument that the Fair Work Act, so far as it applies to non-core New South Wales employees, covers the field when it comes to the circumstances of termination of employment, and there may not be power in New South Wales to deal with this particular issue and regulate this dismissal. So that's something that's, I think, quite an interesting issue, but not tested yet. I've put up the case there of Banning and Great Lakes Council. This is another great case that I like because it was a self-represented litigant against the might of the state, or at least a local council, backed by the state, and he won. He won an unfair dismissal. He said his dismissal was unfair because he was dismissed within the 6 months. I'm not going to take you through all the chronology. The bottom line of the decision from the Commission, New South Wales Commission, was that the 6 months means the period, the incapacity that led to them being off for 6 months. It's not the date of the injury. It's not when they came back on a certificate. It's not when they went off for a while and came back again for a short period. If they came back and did some work that they were required to be done, even if it wasn't pre-injury duties, then the 6 months hasn't begun to run yet. It only runs from when they cease work for 6 months. So what that really means is you need to be doing the rehabilitation from the outset and push it forward for 6 months. And that just puts in a framework of when you can dismiss somebody. The next, and I think the last question, which is quite important again, is this obligation to re-employ somebody within 2 years after you've dismissed them if they're certified fit to come back and do some work. There's two components to this obligation, and I think this is one that does survive the Fair Work Act test because it's to do with what happens after the employment relationship's over, not before. If you've employed somebody to cover the person who's been dismissed for a work-related injury, then you have to tell them that you've covered them and say that your job might go at any time in the next 2 years. It's a penalty provision. I guarantee you that nobody ever does that. I've never seen it happen yet. It just doesn't happen. Now, but what does that mean about coming back to work? There's a case of Tinney and Sydney Water and Sydney West Area Health Service, which deals with the issue, and it basically says when we're talking about putting somebody back to work, if they turn up with a certificate that says they can do a job, and that is a job that the organisation has, it doesn't matter that there's no vacancy. They can still be brought back to work, and somehow you have to adjust and fit them in somehow. You have to have some good reason why you can't put them back in, and it seems from the decision that you can't rely on merit selection and say, well, they can apply for any job that they'd like to apply for and they can get it. That doesn't appear to be an excuse. You need to have to be able to say, look, there is no such job of that kind, or in order to, there's only one of those positions and the person that's in it would have to lose their job. if that person came back, and that's when the Commission will say, well, didn't you tell them 2 years ago they might lose their job when you put them into that position? That's quite a very interesting decision. Now, I think there's one last point to make about this, and where I think we're going to get some more cases from workers' comp coming into the employment space, is that you'll notice that you have to be off for 6 months, then there's this 2 years you can come back within. That comes to 130 weeks, and I'm told by those who are experts in workers' comp that it's after 130 weeks that it becomes easier to terminate ongoing payments. We've seen a slight increase in people who have their payments being terminated wanting to come back to work. So we think this area is going to become more important down the track. I think that's enough about workers' comp to probably bore most of you, and Amber's got to take over.
Not so fast, Mark. We actually have a workers' comp question from the crowd.
Already?
Here we go. With cases that have ongoing long-term rehab and treatment, at what point does reasonably practicable become unsustainable for the employer and the employee? Under what authority can we withdraw duties?
Well, I think it's just paying attention to what the cases have told us so far, which really means you don't have to create a position. I think it's always important to give meaningful work that exists and is required, but it's crucially important to say to the employee, you're going through a process of rehabilitation. This is not your permanent or ongoing job, unless you want it to make it an ongoing job. Be clear about what it is that you're offering. You have an obligation to rehabilitate. You need to draw that to a conclusion if it is not working. So you have to demonstrate the rehab is not working. And that just means getting some medical evidence, assessing it, seeing what's actually happening on the ground, and keeping in mind that there's no obligation to create a position or make one up or just let the person do what they want to do. Part of this is confidence in dealing with it, and we would like to give you some confidence you can move forward on these things once you've actually worked the rehabilitation to a point where it's not going to be successful, but then you should stop, put the person off for that period of 6 months, and then see where the position is at the end of the 6 months and whether at that time it's appropriate to dismiss. I hope that covers it, but we might get a follow-up, and I'll check these while you're talking, Amber, about your little area.
That is indeed actually a great segue into what I'll be discussing, which are obligations in relation to unfair dismissal and then discrimination. So for the purposes of workers' compensation, initially the issue is about suitable duties to rehabilitate somebody to return to the workplace, but it's not about creating a new role. So let's assume we have moved past the 6-month period for the purposes of workers' compensation, and you are going through the process of considering whether it is appropriate to terminate. Dealing with unfair dismissal first. So as we know, valid reason and procedural fairness are generally the two main considerations that we weigh up in assessing exposure in an unfair dismissal claim. It is definitely the case that it can be a valid reason for termination if somebody is unable to perform the inherent requirements of their role, so their substantive position. In that regard, you may think that if you have medical evidence which demonstrates that somebody can't perform the inherent requirements of the role, that you exhaust the process of procedural fairness, that your exposure in relation to unfair dismissal is quite low. But alas, not so. Part of the consideration process for an unfair dismissal claim is a broad catch-all of any other matter the Commission considers appropriate. And I mentioned there a case called Smith and Moore Paragon, which is quite an old decision, but it's definitely relevant in the context of obligations when managing injured and ill employees. In a nutshell, that case concerned two mature age gentlemen who were terminated. Now, in the context, it was part of a redundancy process, but effectively it was in circumstances where comparatively they were selected for redundancy because they could not perform the full inherent requirements of their role. They had both been injured during the course of their employment. They had been on modified duties for an extended period of time. And in going through the process of this comparative selection, it was determined that because they could only perform modified duties, they would be on the cutting block. They said that the selection was unfair. They accepted that they couldn't perform the inherent requirements of the particular position. But what they said was, look, when you consider all of the circumstances, we are both mature-age gentlemen, we work in a regional area, we've been in the same employer, with the same employer for some 30 years. Our ability to find commensurate alternative employment is going to be near impossible. We think that it would be harsh in all of the circumstances. And ultimately, they were successful. What that means for employers is that before there is an automatic reliance on the issue of ability to perform the inherent requirements of the role, consideration really should be given to the individual circumstances and whether, for example, there is any ability to redeploy them somewhere else in the organisation. For unfair dismissal, what you're talking about is whether termination of employment is unfair in the circumstances. So that's the issue to bear in mind. Different considerations come into focus when what we're talking about is a discrimination claim. So moving on to discrimination with my magic buzzer that's not working. All right, there we go. So for the purposes of the disability discrimination legislation, and there are comparable provisions under the state legislation, but essentially under the Federal Act, there is a positive obligation to make reasonable adjustments. What is a reasonable adjustment, you may ask? Well, very helpfully, what the legislation says is an adjustment is a reasonable adjustment unless making the adjustment would impose an unjustifiable hardship. I suspect that's very clear. To be clear, this particular amendment about reasonable adjustments was inserted into the Act circa 2009. It had always been considered that that was the employer's obligation, but there was a bit of discussion during the well-known High Court decision in Purvis that threw the topic into some question. And so to make clear that an employer did have an obligation to provide reasonable adjustments, the legislation was actually amended. What I'm going to do is just step through two decisions which illustrate how this obligation plays out in practice. One of them is very straightforward, that is Dalian and the Australian Postal Corporation. The other one is not so straightforward, Watson and the Australian Postal Corporation, and I am not deliberately targeting the Australian Postal Corporation. It just so happens that these are helpful decisions on this very topic. So the first one, Dalian, was a circumstance where we had a female employee who had been working at Australia Post for a number of years. And she had a back injury, and to assist her to perform her duties, she was a counter personnel who would serve customers behind the counter. To assist her to perform her duties, she needed to have intermittent sitting breaks. So what they had done was provide her with a stool. Now, this particular post office decided to have a refurb, and as part of the refurb, the area between the counter and the back of the room was going to get more narrow, and there was a concern that if she was provided with a stool, it may provide a trip hazard for employees walking behind her. So consequently, the Australian Post decided to withdraw her stool, and this meant that she could not safely perform her duties because she needed sitting down time. So what happened was Australia Post said to her, well, look, we're actually terminating your employment because you can't perform the inherent requirements of your role. And she said, well, actually, I can perform the inherent requirements of my role so long as you give me a stool. And they said, no, we're not going to give you a stool. And not surprisingly, the Australian Postal Corporation was not successful in defending that application. And the court determined that providing her with a stool was in fact a reasonable adjustment, and the alleged work health and safety issues were actually a bit of a furphy. So as I say, that's a reasonably straightforward exercise where it does seem quite apparent that there was a ready solution there for the employer to make that reasonable adjustment. The next decision, though, Watts, is a little bit more interesting. So this is a situation where the particular employee sustained a psychological injury following her non-selection for a leadership position within Australia Post. So apparently it was some leadership training course, she didn't get the gig, and she went off work quite unwell as a consequence. She also made a workers' compensation claim in relation to the stress condition she suffered as a consequence of not being selected and spent some significant time away from work. Now, there was a bit of argy-bargy about whether she did or did not have a legitimate workers' compensation claim. But ultimately, for the purposes of this particular case, there are a number of factors that are relevant. The first is, as a bit of backstory, the court's criticism of the conduct of both of the parties. In this regard, it seems that there was intransigence and a bit of a combative approach by both of them. And the court said delay, prevarication, lack of cooperation, stubborn adherence to process and some obstinacy on both sides all contributed to 2 years passing without Ms Watts returning to work. And the court basically had a lot to say about the fact that, for example, Australia Post hadn't taken a very compassionate or pragmatic approach to resolving the issue, but had been very mired in policy and process. But similarly, the court was critical of Watts, who had been a little bit difficult in terms of requests that she attend for medical examinations and the like. But it's just, I guess, one of those cautionary tales about there can be a lot of value from a practical perspective in cooperation. The second issue that really was at the fore in this particular decision was what would have been required in terms of a reasonable adjustment to assist Ms Watts to be able to perform her role. Now, by looking at the medical evidence, which there was a concern that Australia Post had sort of been a bit difficult in accepting or was not actually applying appropriately, what was really required for Ms Watts was a temporary arrangement for her return. It wasn't a suggestion around restructuring her role or changing basically her substantive position. And what the court said about the notion of reasonable adjustments and what is reasonable is this. In my opinion, matters such as limited working hours, which gradually increased, alteration to supervision arrangements, modifications to face-to-face meeting requirements, amelioration of deadlines being too tight, changes in the kind of work being performed, minimising conflict situations, avoiding the need to lead teams, where all those matters are envisaged as necessary, significantly, for a limited period of time of approximately 3 months, are adjustments which could have been made for Ms Watts without imposing unjustifiable hardship on Australia Post. And I think it's significant to note the difference between the reasonable adjustment in this instance being for a limited duration. Now, if it was the case that there was a requirement that somebody's role needed to change, that deadlines needed to be removed, that they couldn't lead teams, and those were all core aspects of their role or the inherent requirements of the role, and the medical advice was coming back to say, on an ongoing basis forevermore, this employee is not going to be able to perform those requirements, that's a very different issue to what arose in this particular case, which was implementing reasonable adjustments for a period of time to enable her safe return. And in the circumstances of that case, the employer was required to pay $10,000 in general damages to Miss Watts, even though there wasn't any question around economic loss. So in terms of how the defences work, the discrimination will not be unlawful if, as I said earlier, the worker cannot perform the inherent requirements of the particular work even after reasonable adjustments, or if avoiding the discrimination would impose an unjustifiable hardship. Over to you, Mark.
Thanks, Amber. I just want to come back here and just make a few little points again about some legislative obligations. And this one is something that arises under the Fair Work Act. We mentioned earlier about the Constitution and the way that applies, and we need to understand that the Fair Work Act largely deals with employers that, through the corporation's power, are regulated in that way, and they're called those within the federal system. But the Fair Work Act, towards its end, puts in a few provisions that says we want to extend the operation of certain provisions of this Act to all employees, to all common law employees. And they do that under the powers that come through the Foreign Affairs power, where the federal government has entered into treaties and obligations and so on with countries overseas. And as a consequence of that, the federal government then has power to regulate on that topic. And it's done that in certain ways that will affect most but not all New South Wales employees. I say not all because no matter what the federal government wishes to do, there's a limit on how far they can regulate the relationships to do with state government employees, and that barrier comes when the concept of intergovernmental immunities arises, where the federal government is seen as just stepping too much on the boundary, on the power of the state government to engage its own employees to do its functions as a state government. Most often we're there talking about those who might be ministerial employees within ministries, within core functions of government, but it doesn't really cover those who are, we'll say, out in the field doing the work, those involved in transport, education and health and so on. So a couple of the provisions toward the end that are relevant. The main one is that when it comes to termination of employment, if the reason why you're dismissing somebody is because of a temporary absence from work, then you can fall foul of the Fair Work Act if you don't meet particular guidelines. The temporary absence is defined as that period of more than 3 months or 3 months in a 12-month period after the person's entitlement to paid leave, paid sick leave, has expired. There is one decision about whether that covers workers' comp. It doesn't. Workers' compensation is excluded. But if somebody has a month they're off sick for a non-work-related injury, for example, or even a work-related injury, they will have got compensation, but otherwise they'll be on their using up their sick leave. Once the sick leave expires, you will not be able to dismiss them for 3 months, because if you do that, it'd be in breach of the Fair Work Act. It's not often run, but it certainly stands in the background, and our experience is that state government authorities are very careful and thorough before they dismiss somebody, and it's most unlikely that a decision is going to be made and implemented within that 3 months period anyway. But it's worthwhile keeping it in mind. We do now going to move towards some of the important questions. I want to go back and have a quick answer, add something to the question we got asked by Northwest Metro region beforehand, because I realised I didn't quite catch what I wanted to say there. And that is, the question really was asked, under what authority do we get to withdraw those suitable duties? I think this goes back to what Amber was saying at the beginning, that there's all sorts of sources of the obligations. Don't forget the contract of employment. Somebody has been engaged in a relationship of employer and employee to do something, to do a job, to do what they've been engaged to do. The employer, in a sense, has the legal authority within that relationship to ensure that is performed as intended by the parties. So that's sort of where the source of the authority comes from, in a general sense, to stand by the contract of employment. And that's why if a person cannot perform their obligations under the contract, then the employment relationship can come to an end, or in this case you could stop the special conditions or providing suitable duties and so on. Now yes, you've got some hurdles to jump over after that to make sure you've done it in a correct fashion, but behind all of that stands the authority to make that decision if the person just cannot do the job that they've been engaged to do. Okay, now look at some of these common questions, and we've got a few of them up on the board, I think. Yeah, these are old chestnuts, and these are good ones that Amber's going to run through some of these, and I'll look at the last one, I think, of the three, and I'll just monitor the board too to see if anything else comes in.
All right,
Thanks,
so
Emma.
these are 3 questions that we get all the time. So we'll run through those. But as Mark said, if you have others, feel free to add them to the list. So let's talk about the first one. Can you direct an employee to attend a medical? Show of hands from the audience. Oh, that's tricky for us. All right, so employer rights are derived from legislation, the award or the enterprise agreement, the contract. If all of those things are silent, the good news is that under the common law, an employer can make a lawful and reasonable direction. Now, when we're dealing with employers in the private sector, what we always say is ensure that you have a provision of your contract of employment which deals with this issue. That makes life super easy for everybody. For the purposes of those employers who are covered by the Government Sector Employment Act, in good news, under the regs, there is a power to make directions to attend a medical, and that's in 15 sub 2. For those employers who are not within that ambit, the Fair Work Act is of no assistance to you at all. So have a look at the terms of an industrial instrument. But let's assume that none of those are giving you the power that you need. Here are a few decisions which are useful to bear in mind. And ultimately, what is going to be the relevant question is whether the medical assessment that you are directing somebody to attend is relevant to assessing that person's ability to perform the inherent requirements of the role. In the first decision, Cole and PQ Australia, the employer failed to get over the line. The decision's useful because the court provides a lengthy checklist of questions to consider, and this is in assessing whether it is reasonable in the circumstances. But essentially, this was a circumstance where the Commission ultimately formed the view that the medical to which the employee was being directed was not actually for the purpose of determining the employee's ability to perform the inherent requirements of the role. That can be compared to these 2 more recent decisions, and in particular, Grant and BHP Coal has gone all the way to the full federal court. Operating in the background in that particular decision were quite specific work health and safety obligations for the coal industry, and it did make quite express that an employer had an obligation to ensure that people could perform work and could perform work safely. So the court was satisfied that the direction was both lawful and reasonable. Mr Grant was concerned that requiring him to attend a medical was an infringement of his personal liberty. But as I say, the court was quite prepared to accept that it was lawful and reasonable having regard to the statutory environment in the background. What does that mean if you don't have coal-specific work health and safety legislation? Obviously, there's the general work health and safety obligations to provide a safe place of work. So that can usually be sufficient to enable the employer to make that lawful direction. But just be careful that you're not wielding it around willy-nilly. Going back to coal, as I say, that's an example where the employer was basically not linking the medical assessment to ability to perform the inherent requirements of the role. Another question that comes up all the time is the extent to which an employer can challenge a medical certificate or simply not accept a medical certificate if the employer does not believe the employee. This is a great case. This is an unfair dismissal case. So here's the backstory. There was a particular employee who booked flights to travel to India for 4 weeks. She did that before she had her leave approved. And then when she asked to have her leave approved, she was actually only granted 1 week. So she travelled to India, and lo and behold, while she was in India, she sent back a doctor's certificate saying, unfortunately, she would not be in a position to return to work at the conclusion of her 1 week's annual leave because she was unwell. Now, the employer's response to that was to deliver a box to this particular employee, which included all of her personal belongings that were in the office, with a letter indicating that her employment had been terminated. And she brought an unfair dismissal claim. In the final wash, her application was successful and she was granted 13 weeks compensation. Why so, you may ask? Well, it transpires that this particular employee was actually sick when she was in India and she was actually hospitalised. But apparently the employer had made the assumption that she was pulling a swifty, to use a technical legal term, and did not actually make any inquiries to determine the legitimacy of her doctor's certificate and claim to be entitled to personal leave. So, in those circumstances, given that she was genuinely sick, the Fair Work Commission found that there was no objective reason to reject the certificate. So obviously the take-home message there is certainly an employer can challenge a medical certificate. What form can that take? An employer is not entitled to seek details beyond what is provided in the medical certificate without the employee's consent. So, for example, an employer can certainly call the doctor and say, look, can I confirm that you've issued a medical certificate? If the employer wants further information about the illness, that information should be obtained with the employee's consent. I've been asked the question whether the employer is entitled to know the nature of the illness, and the answer to that is no. The only factor that is relevant for the purposes of the employer is whether that person is or is not fit to perform their particular role. But the key is you can't just make the assumption that the employee is pulling a swifty without actually making inquiries to back up your position.
That's right. Back to me. I want to support what Amber said in giving that answer. It's quite a difficult area, but employers are entitled to say to their employees, look, we need you to cooperate with us, we need to make decisions about your employment, and we think it's reasonable for you to tell us what the condition is, because we need to assess you in the workplace and we'd like you to give your consent to your doctor speaking to us about it, or perhaps sending along the job description, explaining to the doctor what the work involves, to make sure that the doctor is in fact making an assessment as against what the particular condition is from which the worker suffers. So there's a lot of work you can do in the background about making sure the issue is a live one and is not being just allowed to be subject to the medical certificate and nothing else. This question about asking about certificates feeds back into this question we get asked quite often, where people want to ask somebody at the interview, or they put on the form for applying for a job, ask about workers' compensation history. And they say, well, can you ask that? And I always say, well, why are you asking? What's the reason? What's the purpose of it? Because if you're going to proceed in this way, you need to be able to explain why it is you're asking the question. The answer we often get is, well, people have got a workers' compensation claim in the past, they might make another workers' compensation claim. Or they might say, well, it might mean they've got an injury, which might mean they're at risk of further injury in the workplace. That might be true too. Or maybe they've got an injury which means they can't do the work that they've got to do. Well, that might be true of all sorts of people, even those who have not had a workers' compensation claim in the past. So you're starting from the wrong position about asking about workers' compensation claim. What you've got to do is ask what Amber's been saying. You've really got to ask the question of the person who's applying for the job, do you have some condition that's going to prevent you performing the inherent requirements of the job, and for which we could not make any reasonable adjustments without incurring an unjustifiable hardship? It's not an easy thing to, once you frame the question in those terms, to get the answer that you want, because most employees are going to find that a very confusing question and unable to answer it. That sort of leads into the next part of it, which I want to deal with the two of them together, where people say, well, look, you know, it's turned out that when they came to work, they didn't answer their question. They said they didn't have a workers' comp history, and we now find out 3 weeks later they've got a workers' compensation claim because the rehab coordinator from their last job wants to see what they're doing to make sure the rehab's okay. So we want to sack them for dishonesty. That's a really hard thing to do for lots of reasons. I'm just going to give you two main ones. quite often the employee has a different view about the information that you're asking. And they might quite rightly say to themselves, this employer has no right to ask me about my history unless they've actually asked it properly about what affects the inherent requirements of the job and for which they can't make adjustment. If they'd asked a specific and precise question like that, I might have given them an answer. But if they're asking me a question I don't have to answer, I don't need to give them an answer. And that's not a bad response. Why have to answer a question that can't be asked in the first place? Also, if you're going to dismiss somebody for dishonesty, you need to demonstrate that honesty is a particularly important aspect of this position. Are they being employed as an auditor? Are they being employed as a lawyer? Are they required to check and confirm the accuracy of certain information so that an aspect of dishonesty might mean they can't do the job properly? If you can tie it to all of that, you might have a bit of an argument to say you need to dismiss somebody because of dishonesty. So putting those two things together, the only question you can legitimately ask at the outset is, when you start this job in 3 weeks' time, is there going to be some issue that we have to deal with that will prevent you doing the inherent requirements of the job and for which we couldn't make a reasonable adjustment that won't cause us unjustifiable hardship? And that won't be done just by handing over the position description and saying, check this is okay. You can do risk management stuff by asking about what weights can you lift, what can you do, what sort of work's involved. All of that's useful for meeting your work cover obligations and avoiding risk of injury, but it can't be a criteria for deciding whether somebody should have a job or not have a job. Now, I think that question were the ones you wanted. I think we've probably picked up on all the questions that we've been asked one way or the other. And I wonder if we just want to get to our practical tips now in the few minutes we've got left. If you've got any more questions, send them through. Otherwise, we just want to summarise what we think are the practical tips. First one, there are a lot of obligations. In our talk, we've had to slide backwards and forwards to some extent between what happens in the federal sphere, what happens in the state sphere, and that's because even those who are working under the New South Wales government, some of those people are picked up with particular Fair Work obligations or are comprehensively governed by them under enterprise agreements and things of that kind. But even behind all of that, the general principles are pretty much similar. There's some detail at the edges which can matter in particular circumstances, but the principles remain the same, that you can deal with work-related injuries essentially by, if it's a work injury claim, doing the rehabilitation as well as you can, as hard as you can, really trying to get the person back to work. If it's not working, stop it. Take that 6 months and then see where you are after that. If it's not a work-related injury, you may well, as a matter of policy, want to assist somebody with some adjustment to get them back to work because it's better to keep somebody in work rather than have a lot of turnover. But even then, if it gets to the stage where they can't do their job, you're going to have to wait that 3 months. So, Amber, any of those you want to pick up on?
I must admit, Mark, I have been concentrating on our question board and it appears that more have arrived. So shall I ask some?
Yes, please.
The first one, actually, I'm going to jump in and I'm going to answer it. The question was, what are some recent federal court cases on reasonable adjustments? The best decision to which I can refer you is Watts and Australian Postal Corporation. That's, I think, early this year or the end of last year. But that's a very recent, comprehensive decision on reasonable adjustments. Try there first, and if that doesn't help, give me a call. This one's for you, Mr. Paul.
Yes.
From the New South Wales Police Force. If an employer has a certificate from a nominated GP, a report from a treating expert, example, a treating psychologist. So we've got GP, we've got treating expert, and then the employer has paid for its own independent report, example from a psychiatrist, and now we're up to 3. Is it open to the employer to then rely on the report that most suits its needs?
You can have a go.
Or will it
there's
be bound to accept one over the other?
Well, in the end, it's going to be an analysis of what, if there's a dispute, the court's going to decide or the commission's going to decide is the best evidence on the issue. And that really involves interrogating the information, sitting back and thinking about it, maybe getting all of the doctors together and pointing out to them, when I say get them together, pass the reports around. We've got this report, we've got that report, what do you say about it? But perhaps more importantly, having a very good idea of exactly what the work involves that the person has to do. What precisely are they required to do? How do all of these issues affect their employment? I can give you one quick example. I was involved in a case quite some years ago where an employee had a doctor's certificate to say he couldn't work on certain machines in a pathology laboratory. There were 4 machines. The work had to be done on all of the machines. People had to rotate and share the work. He only wanted to work on 2 of the machines, and he had a doctor's certificate to say he couldn't work on the other 2 machines because he had a bad knee. It was backwards and forwards with arguments. We wrote to the doctor, tried to get an assessment, sent in the position description, asked him to look at it closely, sent across our own expert's report about it, and so on. It was getting nowhere. We finally threatened dismissal, and the employer put on a threatened unfair dismissal claim, as they can do in the New South Wales regime. We found ourselves before one of the commissioners. We resolved it in the end by the suggestion from the Commissioner that we have the medical practitioner come out to the workplace and look at the workplace. The doctor, to his great credit, did that. We said we'd pay for his attendance. He came out to the workplace, walked into the room where the work was to be carried out, and said in about a minute and a half, yes, he can work on all 4 machines, provided you buy him a kneeling stool. Now that I see how the machine's laid out, what its dimensions are, what its location is, what the spaces are around, there's no reason why he's not able to do it, provided you provide a kneeling stool. And it was resolved as quickly as that. So that shows the extent you might have to go to, but it's not a question of playing cards where one goes against the other and this one beats that one beats that one. You've got to tease out the information, put it all together and make some measured view about it, and then state what it is in a way that you think you can defend. Because eventually this will go in a letter to the employee saying, we're thinking of dismissing you for these reasons because you can't perform the inherent requirements, and this is the information we've got that we're relying on to make that decision. And they can respond to it, and you see where it takes you. That it?
It appears we have no further questions.
Good. We've probably exhausted our group. A lot of fun speaking to you. We're going to conclude, I think, now, and just remind you that our next one is the odds and ends. Laws worth knowing about in employment, and Amber will be back with James Matson in 3 months.
That gives me something to look forward to.
Yes. Thank you.
Thanks very much indeed.
Bye.